Hi everybody, my name is Frekhtman. I'm an attorney here in New York. And in light of recent events, I wanted to talk about the legal standard for excessive force or police abuse, police brutality cases in New York City. So I looked at all of the cases from January of 2020 up until the most recent case was May 28th of 2020. And it was from the appellate division, which is the highest court. And I looked at all these Supreme Court trial cases. And basically what the law is saying is that the use of force by a police officer must be judged from the perspective of a reasonable police officer on the scene. So we can't use 2020 or hindsight or what some people call armchair quarterback, like Monday morning quarterback type of analysis to think, well, if we go back, you should have done X, Y, or Z. But we have to look at it from a reasonable person standard. And that's the same standard that's used in negligence cases. So for example, if somebody runs a red light and hits another car and it's a simple car crash case, the standard that the jury is told about and the standard upon which they make their ultimate decision, the verdict, is going to be that of an ordinary person, what an ordinary driver would do, what a reasonable driver would do. So the same thing applies to police officers. And the law actually recognizes that these split-second judgments often come in circumstances that are tense because of a standoff between, let's say, somebody that the police officer thinks has committed a crime and the police officer, him or herself. That standoff is often tense, it's often uncertain, and it's rapidly evolving. The situation could change quickly. So because of these things, the amount of force that's necessary in any particular situation is therefore usually left for a jury to decide. So courts don't like to make a decision that something is reasonable or unreasonable as a matter of law.